This lesson will focus on the First, Fourth, and 14th Amendments. In this lesson, we will briefly review constitutional law and then spend most of our time discussing the First, Fourth, and 14th Amendments, and close by talking about legal remedies available to plaintiffs if the defendant is found guilty of violating one of your constitutional rights. We can first start by discussing constitutional law. We are going to focus on the US Constitution rather than individual state constitutions. So the US Constitution is the supreme law of the land. And when considering the amendments to the US Constitution, the First, Fourth, and 14th Amendments are aspects of constitutional law that most affect participants and managers of sport and physical activity. Now, thinking about constitutional amendments broadly, they are designed to protect our individual rights. So our right to free speech, to free religion, our right to be free from unreasonable searches and seizures, our right to equal protection under the law. So constitutional amendments reflect provisions and protections for our individual rights. And the Constitution protects our individual rights by prohibiting certain governmental action. So based on this requirement of prohibiting governmental action from infringing upon our individual rights, it is impossible for private parties to violate constitutional amendments. And so anytime a lawsuit will allege a constitutional violation, the plaintiff must first demonstrate state action. Now, state action is the action of any governmental entity. So that can be at the federal, state, city, or municipal level. But this action is performed by a governmental entity or any actor within the governmental entity. So when thinking about who constitutes state actors, I'll give you a few examples that pertain to sport. Typically, the activities of public schools, universities, and their officials, so coaches, teachers, for example, are considered to be state action, as those entities are controlled, they are funded, they are directed by state or local governments. So once again, public schools, like you'll see on this slide, Columbus City Schools, Ohio State University, and their officials, which you'll see these are athletic trainers at Ohio State, are all subject to the Constitution. When considering other organizations that are relevant to sport, the majority of courts will consider high school athletic association as state actors because of their involvement with the state and their purpose of fulfilling state functions. When considering the NCAA, I think this is particularly interesting. They were considered state actors up until the mid-1980s, but since the 80s, the courts have found the NCAA's actions to not constitute state action. So their rules and activities are now generally found outside of state action. So they aren't subject to the Constitution as much as our university, for example. When it comes to college conferences, it really just depends. It depends on the members of the conference, how many are public and private, if the conference receives direct or indirect tax breaks or concessions from the state, if the conference members use public facilities. So there are a lot of factors that go into considering whether college conferences are state actors. And then a couple other examples, the United States Olympic Committee has generally been found to not constitute a state actor. So even though the USOC was created by a federal statute, its actions are so far removed from the state that it is no longer a state actor. And then professional sport leagues, these will also be considered to be private actors. So their action does not constitute state action. And the reason for this is that professional sport teams and leagues do not perform a function that is traditionally performed by the state. They are not significantly entwined with the government in their actions and in their decisions. So their internal operations, their funding, their facilities are truly private. So those are some examples of who can be considered a state actor versus who would be considered not a state actor. And once again, only state actors and state action are subject to the Constitution and the prohibitions within the Constitution. Now, there are times when a private actor's actions may transform to become state action. So while the NCAA, USOC, and MLS, for example, are considered to be private actors, their individual actions and specific conduct may potentially transform to state action and therefore be subject to constitutional review. And the courts, to determine whether a private actor's actions constitute state action, will use these two theories that you see on the slide. So they will use the public function theory or the nexus entanglement theory to evaluate the action of these private actors. The public function theory considers whether a private actor is performing a function that has been traditionally reserved to the government or is governmental in nature. So only the activities that are traditionally associated with the government and operated almost exclusively by the government would be deemed a public function and therefore subject to constitutional review. This theory is used a bit less often in sport because we're not typically performing functions that the government would fulfill. But a couple examples might be if a sport organization is monitoring the activities on, let's say, the sidewalks right outside their building or facility. So if a private citizen is handing out religious pamphlets or is protesting on sidewalks outside of your sports stadium and you stop that action, you are prohibiting their freedom of speech. In that case, you may be subject to the Constitution, even if it's nationwide arena. If you are prohibiting citizen behavior on public sidewalks that are immediately outside your stadium, well, guess what? The enforcement and monitoring and maintenance of those sidewalks is a function traditionally reserved to the state. Another example that I've seen is if a golf club reserves membership to residents in certain zip codes, just for, I don't know, their target population. Well, in the past, the government has seen that as almost creating like a zoning ordinance. And so you just need to be mindful about the functions that you're fulfilling as an organization. And the other one, nexus entanglement theory, examines the relationship between the state and private actor and whether the state's involvement with the private actor is so entangled. I want to emphasize that, so commingled and entangled that it then transforms the private conduct into state action, which is then subject to constitutional review. So this relationship between the private actor and the state, it must be more than just receiving state funding or being regulated by the state or having access to a public facility. It needs to be joint participation between the state and private actor. So often what we'll see in professional sport is that a professional sport organization may receive some funding from some funding from the state in order to fund their facility. They may have access to a public facility. They may even have access to police officials to provide extra security during their events. But that is not enough entwinement to make the private actor's conduct considered state action. The interaction between the state and the private actor really needs to be really entangled. So an example might be if the state, so going back to police officials, if the state is actively engaged in the decision-making process of the internal operations, like the police department is giving input into the security measures at the stadium and developing policies and developing protocols. Well, in that case, the state is actually engaged in the internal operations and decision-making of the private actor, and then the private actor's conduct would constitute state action. So I just wanted to show that there is a bit of a blend, and private actors have been found subject to the Constitution if, according to these theories, they're either fulfilling a public function or are entangled with the state. But once again, when there is a constitutional violation cited in a lawsuit, the first question is going to be, is there state action? If there is not state action, then the lawsuit can be dismissed because only state actors and state action are subject to constitutional review. Next, let's discuss the First Amendment to the US Constitution. So the First Amendment to the Constitution focuses on freedom of speech, freedom of religion, freedom of the press, the right to peaceably assemble, the right to petition. There are a number of freedoms that are contained within this First Amendment. On this slide, we're going to focus on the freedom of speech. And you'll see on the picture on the top right side, this is from the 1968 Olympics when gold medalist Tommie Smith and bronze medalist John Carlos showed the raised fist on the podium after their 200-meter race at the Olympics. At the time, both were wearing Olympic Project for Human Rights badges. And so through their expression, which in this case was nonverbal, they were promoting human rights. And similarly, what a more recent example that you'll see on the picture to the bottom of this slide is Colin Kaepernick, who back in 2016 was entering his 6th NFL season for the 49ers, chose to sit on the bench during the national anthem before the 49ers played Green Bay. And in his response to media questions, he indicated, "I am not going to stand up to show pride in a flag for a country that oppresses Black people and people of color." And so through his expression, which once again was expressive, it was nonverbal, he remained silent, and he was in his silent protest really advocating for racial justice for Black people and people of color. So those are some examples, powerful examples we've seen in sport, where athletes are using their freedom of speech to speak, remain silent, discuss with others, advocate, and communicate ideas to further our country. Speech may be verbal or expressive, so the examples were expressive, but speech can also be verbal. However, not all speech is protected under the First Amendment. So defamation, obscenity, fighting words, words that create clear and present dangers, so that might be like shouting bomb in an airplane and causing panic. Speech that advocates the commission of a crime, and then sometimes speech that is lewd or slanderous, libel. All of those types of speech are unprotected because they are not for the good of society. However, the majority of speech is protected. And when a plaintiff claims that their freedom of speech was violated, there are a few steps that the courts are going to go through. The first step is they are going to consider state action because once again, the defendant needs to either be a state actor or their action needs to constitute state action for them to be subject to the restrictions of the Constitution. And then the court will examine the subject of the speech. Is it protected speech or is it non-protected speech? Because if it's not protected speech, then you can be restricted from engaging in that speech. Non-protected speech is, as you would assume, not protected under the freedom or under the First Amendment. They will then examine to whom it was directed. Youth populations have a greater protection in this case because they are minors. They will examine the forum in which it occurred. Is it commercial speech? Is it advertisement? Is it in a private setting? Because all of that will inform their judgment, which we'll talk about in a moment. And then the manner of delivery as well. So the states are going to consider all of these factors because it will inform the standard of review that they will apply, which we'll also talk about in a moment, and how much protection the plaintiff should receive in that particular case. Now, when thinking of sports, I wanted to point to the special characteristics of the school environment because there are a few exemptions that school officials, which would include the athletic administrators and coaches, exemptions that you have due to the special characteristics of the school. So exemptions meaning you have some rights to prohibit the speech of students in certain circumstances. Now, the pictures on this slide, oh my goodness, the Tinker versus Des Moines case is a critical case when it comes to freedom of speech and student rights. This case is back in 1965. It went all the way up to the Supreme Court and was just a huge precedent when it comes to students' rights to free speech when in schools. And in this case, Mary Beth Tinker, who is 13 years old at the time, she and a group of students decided to wear black armbands to school to protest the war in Vietnam. And the school board got wind of this and they passed a preemptive ban, not allowing them to wear their armbands. These students were asked to remove their armbands and then were suspended. And in response, those students, which is just wonderful, they filed a First Amendment lawsuit for their freedom of speech. And it went all the way up to the Supreme Court. And in 1969, the Supreme Court made that, this quote will probably ring a bell to you, just this really powerful judgment that says that students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gates. So it was through this case that students' freedom of speech really was protected. And so you have to be careful of what speech you can and cannot prohibit. Now, school officials can prohibit speech that is creates a substantial disruption. Now, this applies both to school officials and to athletics. So focusing on athletics, for example, student athletes, they do have their freedom of speech. Once again, it is not shed at the schoolhouse gate. However, their speech cannot substantially and materially interfere with the operations of the athletic department or collide with the rights of others. Now, when thinking about speech that is substantially disruptive, it needs to do more than just merely be uncomfortable or unpleasant or unpopular. This speech needs to so substantially interfere with the internal operations of the school or of athletics that your coach, your athletic administrator is no longer able to effectively coordinate the activities of the athletic team. They're not able to just properly administer their sport activities because of this substantial disruption. So there are a few reasons why there's this protection that we see in athletics, and a few examples here are student athletes tend to have less freedom to speak out because a coach needs to maintain order and discipline in order to effectively run their team. And a protest is typically not going to substantially disrupt the team if a protest does not substantially disrupt the team or interfere with the team's activities and the coach's authorities, then that speech is permitted. So the example I wanted to throw on this slide is Cardale Jones' pretty famous quote about we didn't come here to play school, we came here to play football. While certain student athletes' remarks may have a negative impact on the university in terms of their image and their PR. If it doesn't disrupt team activities, it cannot be prohibited. There are a couple other exemptions that school officials receive. Students cannot encourage illegal activity. If they do, that can be restricted, that speech. And then also, there is a general notion that school officials are almost guardians for minors when they're away from their parents. And so to protect minors from vulgar and offensive language, school officials can prohibit certain types of speech, like sexually explicit speech in front of children, for example. So a few exemptions I wanted you to be aware of. In sports, it's predominantly the substantial disruption exemption, but I really want you to consider, is the speech truly a disruption? And so social media, athletic policies, be mindful of your language. You can provide guidelines for what speech student athletes can and cannot engage in. However, be very mindful about what speech you're actually prohibiting and consequences that you are enforcing based upon student athlete speech, because you could be liable for a First Amendment violation. So you can provide guidelines, you can provide coaching, but students do have freedom of speech. Another freedom that we see in the First Amendment is the freedom of the press, which includes freedom to write, draw, create models, publish, and convey ideas. So similar to freedom of speech, it's almost another form of expression just through print, through radio, through television. When a violation of the freedom of the press is filed in a lawsuit, the courts will once again consider, first, is there state action, because there must be state action for constitutional review. Next, they will consider the nature of the speech. Is it protected or unprotected? Because unprotected speech, guess what? You have no protections under the First Amendment. However, they'll also examine whether it's commercial or advertisement speech, just because that type of speech receives less protection. So basically, everything else receives the highest value of protection and the highest level of scrutiny from the courts. However, commercial speech is a little bit less protection, and then unprotected speech has no protection. They'll also examine the nature of the medium. Is it print medium? Is it broadcasting? The courts have given the greatest level of protection to print medium, and the lowest level of protection to broadcasting based upon how the scope of how accessible those publications are. Now, print medium has a fairly limited publication base, whereas broadcasting, it can be quite invasive and it's very accessible. It can quickly spread. So when thinking of, let's say, defamation, the damage that can be made by a TV or radio broadcast being shared worldwide. So that's why broadcast, because it has such great access and scope, has the lowest form of protection, because speech can be quite damaging. And then with the internet, just in terms of our particular context, courts have found that school officials are not authorized to censor the internet, even if that internet is accessed at the school. I just thought that was pretty interesting when it comes to like university libraries and things of that nature. Another freedom that we experience is the freedom of religion in the First Amendment. So the freedom of religion has two really important clauses that pertain to what state actors cannot do and what protection individual citizens have. under the First Amendment. So the first clause that we are going to discuss is the Establishment Clause. And the Establishment Clause, as you'll see on this slide, prohibits any state actor from making any law, policy, procedure, regulation, anything that establishes or promotes a religion. Now, historically, the courts have used three different tests to determine, did a state actor promote a religion and therefore impose a specific religion on a individual citizen, which is not permitted under the First Amendment. So they'll use the Lemon test, the coercion test, or the endorsement test. The Lemon test is actually not used very much anymore, just because it's been criticized for not being adequate enough to determine whether there was a violation or not. But you'll see the three prongs that are considered under the Lemon test. The courts would examine, does the statute, rule, policy have either a secular purpose, which in that case wouldn't violate the First Amendment, or does it advance or inhibit religion, which would violate the First Amendment. And then they'll also examine if the statute, rule, policy fosters excessive government entanglement with religion. So once again, we don't want that entanglement. The coercion test and endorsement tests are used most commonly, and that is looking at whether a statute, a rule, I say a policy and procedure because this also is relevant to sport organizations that are state actors. Does that have a coercive effect? Or does the conduct of a state actor have a coercive effect or potentially endorse a specific religion or disapprove of a specific religion through the policies or practices of the state actors? Essentially, sport organizations that are state actors must remain religiously neutral in their official capacity at work. Now, within sport, we have seen just a couple of pictures on this slide. Prayer in public schools has been heavily debated in the court system because who is leading the prayer, and what does that message convey? And so courts have previously found that when prayer is led by a school official, so a coach that for example, that you'll see in this slide, it can have a coercive or endorsing effect because it is potentially promoting one religion over another. And I'm talking about more than just having a silent moment. We're talking about public officials actually leading prayer in this case. And so there's a difference between government speech that is endorsing religion and private speech that is endorsing religion. With the Establishment Clause, we're focused on government speech endorsing religion, which is prohibited, but includes the actions of public officials in their official capacity in their job. So previous court rulings have held that prayer in schools should be student initiated, truly student initiated. And representatives of the school should not be leading the prayer. Now, conservatively, the court suggests that those representatives should also not be engaged in or observing the prayer, as it could be considered endorsing religion, but I think that's quite conservative, so that would be up to you. A picture on this slide that I want to point out is Coach John Wooden, who is, oh my goodness, an amazing coach, basketball coach for the UCLA, who has passed. And he's known for the pyramid of success, which he used to coach his athletes. And part of the pyramid of success was faith. But faith could be considered, part of wellness, part of success, as long as you are not endorsing a specific religion. You can support an athlete's spirituality, their faith, their belief in something greater. But you just need to be mindful about what specifically you are endorsing. The other clause within the First Amendment that pertains to freedom of religion is the Free Exercise Clause. So this focuses on the freedom to believe and the freedom to act for all individual citizens. So in this case, it prohibits state actors from making any law, rule, or policy that interferes with your freedom to exercise your religion. So they cannot interfere with your religious beliefs unless the general application of this law, rule, or policy has a non-religious purpose. You don't see this very often, but an example might be if the legal authorities prohibit the use of controlled substances during a religious ceremony. So extreme cases, but for the most part, they should not interfere with you practicing your own religion. And a couple of pictures on this slide, you will see Iptaj. I was practicing her name this morning. Muhammad, who's an American saber fencer and a member of the United States fencing team. And she is known for being the first Muslim American woman to wear a hijab while competing for the United States in the Olympics. And then she won the bronze in her hijab. And so that is just what a great example of freely exercising her religion in the midst of sports. And then the other example you'll see on this slide is Dabo Sweeney, who coaches the Clemson Tigers, and he is known for his faith and has been quoted by saying, "I'm a football coach, yes, and people identify me as that, but I hope they see Christ in me as I do my job." And so he has continued to engage in his religion while in his, okay, let me go back. He has the freedom to engage in his religion as an individual citizen, even though he's also a public official and a state actor. So there's a really interesting tension, I think, between the Establishment Clause and the Free Exercise Clause, because if you are a public official or a state actor, that doesn't mean that you lose your free exercise of religion. You don't lose your freedom. You just have certain restrictions when acting in your official capacity as a public official. So there just needs to be a little bit of boundaries between who you are as an individual citizen and who you are as a public official. It's super, we can talk about this more. I find it a really interesting tension, but I want you to know that your freedoms still remain, even if you are a public actor. So let's move on to the Fourth Amendment, our next amendment. And as you will see here, that the Fourth Amendment is the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. So that cannot be violated. And when there is a lawsuit that is claiming a Fourth Amendment violation, typically the courts are going to try and balance the individual citizens' interest in privacy against the state actor's right to maintain order in an environment in which others can be safe. So I wanted to show this picture on this slide, and I'll have the next slide highlighting this. We see search and seizure in a lot of different ways in sports. One prominent way is through the security screening when fans are entering a sports stadium, because a state actor would want all patrons within the stadium to remain safe. And so unfortunately, it has become more and more necessary due to terrorist attacks and other events that have occurred in sports stadiums. It is critical that patrons are screened and searched to make sure that they are not bringing in prohibited items and potentially increasing the risk of other patrons in the facility. So that would be an example of conducting a search and potentially seizing their property. When a lawsuit is cited, the courts will once again consider several factors. I hope you're starting to see a theme, because the first thing they're going to ask is, are they a state actor? Either are they a state actor or does their conduct constitute state action? So that's always the first question. If they're not a state actor, the case can be dismissed. And then next, they're going to examine, is the conduct a search? So a search occurs when there is an expectation of privacy, which is infringed upon. So for example, I have a general expectation of privacy that people aren't going to rifle through my stuff, right? That people aren't going to ask me to open up my purse and look through it. So if that expectation of privacy is violated, then in that case, it would constitute a search. When it comes to drug testing, I have an expectation of privacy that I get to pee alone, that someone's not going to be in the stall watching me pee. So that would be another example of a search. And then next, they will consider, was the search reasonable? Because the Fourth Amendment only prohibits unreasonable searches. So when trying to figure out this term reasonable, the courts are going to ask, was the search justified? At its inception, do you have a reason to search? As I mentioned with sports stadiums, because of past terrorist attacks and because of past events of fights with crowd management issues, they have a reason to screen patrons. With drug testing, because of past athletes who have taken PEDs, there is a reason to test whether athletes are taking drugs. So is there a reason? Is the search justified? And then is the search reasonable in scope? So they're going to look at, were the measures reasonably related to the objectives of the search? Were the measures intrusive in light of the age and sex of the individual and the nature of the infraction? So once again, going back to drug testing, what we'll see in like high school and college sport is they're going to ask for a urine sample. They're not going to ask for a hair follicle. They're not going to ask for a blood sample. And so what is the degree of the what is the degree of the intrusion? When I enter a sports stadium, okay, yes, walk through a metal detector. They might, open up my purse, but I am anticipating not having a pat down search, for example. When you're creating these security measures and security policies and potentially engaging in searches and seizures, you should consider how intrusive the search is in light of the objectives of the search and the population that you're working with. Minors, once again, always receive greater protection. So here's an example of security screening, and this is, I would say, a pretty common example of the clear bag policy that's now in effect. Often when entering sports stadiums, they will use metal detectors. They'll indicate what bags you can bring in. There will be policies about what items are prohibited. So if those items were found on a person, those items could be seized because they are either unsafe or could infringe upon another patron's experience at the sport event. So look, all prohibited items will be deemed surrendered and will be disposed of, so they can be seized. And then you are searched by going through a metal detector, by potentially having a wand if you make the metal detector go off, and potentially having your bag looked through. I wanted to take one moment to focus on drug testing in sport, just because that's probably where we found the greatest lawsuits when it comes to the Fourth Amendment. So drug testing of athletes continues to be a popular deterrent mechanism that is utilized in professional, collegiate, and high school sports. Now, there are a few arguments for why there is drug testing. For one thing, first thing, drug testing, urine testing specifically, constitutes a search and seizure. So there's questions of, is it a search? Is the search reasonable? The courts have considered that. And for one thing, urine collection is considered a search because there's that privacy implication. It's embarrassing. It's degrading having to pee in front of someone. So it violates your privacy. It violates your Fourth Amendment. The chemical analysis of urine violates your medical confidentiality because it could reveal some private medical facts. And then also, urinalysis testing can attempt to regulate your off the field personal conduct, which also is a violation and infringement into your personal privacy. However, I thought this argument by the courts was interesting. They have found that student athletes have a lesser privacy expectation, which will influence what is considered a reasonable search because of the communal undress uh, nature of sports that we see in some athletic teams. So when communal undress just means, you're changing in front of other athletes, there might be communal showers. And so in general, when you're participating in sport, you have a little bit less expectation of privacy because you are exposing yourself in those ways. And so your protection for privacy is just a little bit less because of that, which I thought that was interesting. And then on the flip side, so we have our privacy interests, and once again, the court is going to weigh the privacy interests of the individual citizens with the governmental interests served by violating this Fourth Amendment right. So in this case, with urine testing, there are a number of different governmental interests that are served. You'll see on this slide, providing fair and equitable competition, guarding the health and safety of athletes, trying to deter drug use are some of the, I would say, of the largest arguments. And then just a couple of court cases that have been really major. Back in the 90s, there was a Supreme Court case, Acton versus Vernonia in 1995, and it was that case set precedent upholding the right of public schools to randomly test athletes for drugs because of the governmental interest served. So even though school officials are not legal authorities, right? They are not police officials. They do have the right to engage in drug testing. So to engage in searching and seizure without a warrant has been upheld in the courts. And then in 1994, there was a Supreme Court case, Hill versus the NCAA, and that also upheld the NCAA drug testing program as not violating the student athlete's constitutional rights. So historically, the drug testing policies that are currently in place in college athletics have been upheld. However, you really still need to be mindful of the degree of intrusion, your policies and practices to make sure that your search is justified, your policies and practices are fair and consistent, and I would say on par with industry standards. So just be mindful of what all the other universities and the NCAA are doing, and make sure your drug testing is reasonable and justified. And the pictures on this slide is found really interesting in terms of drug testing. You can drug test through a blood sample, through saliva, through a urine sample. Now, urinalysis is most common in high school and college athletics, and then through a hair sample. And this is the window of detection, which I just thought was super fascinating, that with the hair sample, it's considered the most invasive because you can pick up on drugs that were taken weeks or months ago. Whereas if you collect a blood, saliva, or urine sample, you're only going to be able to detect drugs that have been taken within days, maybe a week. So this kind of gives you an illustration of what would be considered more or less invasive. And then over here, we're seeing from WADA the sports that have the greatest anti-doping rule violations. So the biggest ones are like bodybuilding, cycling. Athletics are all the running events. Powerlifting, weightlifting is where we're seeing most of the violations. All right, our last amendment to review is the 14th Amendment. And within the 14th Amendment, we are going to focus on the Equal Protection Clause, which states that no state shall deny to any person within its jurisdiction the equal protection of the laws. When this amendment was first created, it was actually not intended to be applied to all people. It was meant to provide some rights to African American men. But since its inception, it has really expanded to be a seminal, critical protection for all people to be treated similarly. So this clause requires similarly situated people to be treated similarly. And if they are not treated similarly, then the state actor must be able to justify the governmental interest served by treating one group differently than another group. So you'll see in these graphics on this slide that this equal protection clause, it is relevant to all people groups, to immigrants, so I'm going to focus on our minority population here: immigrants, women, people of color, people who have a disability, for example, are all protected under the 14th Amendment and should not be discriminated against. Now, because this is a US Constitution, if there is a 14th Amendment violation, it doesn't state this here, but I wanted to reiterate that the courts will first consider whether the defendant is a state actor or they are a private actor whose conduct constitutes state action. So that will always be the first question asked. And then they're going to examine the discrimination, how the plaintiff was treated differently than similarly situated people. And by similarly situated people, an example might be the lawsuit for the US women's national team comes to mind. They are trying to argue unequal pay. Now, different law here, but I just think it's a great example because they are trying to articulate that similarly situated, right? We perform the same tasks, responsibilities, we have the same burdens, we engage in the same effort as the US men's national team, and yet we are not paid equally. So that's just an example of being treated differently. Now, the 14th Amendment only protects against intentional discrimination. So I wanted that to be clear. Unintentional discrimination or disparate impact may not mean that your 14th Amendment right was violated. So disparate impact, you'll see a description on the slide here, is when one group is just more greatly burdened by a classification than another. So for example, if a Title IX has now allowed women to try out for men's contact sport teams, particularly when there is not a female equivalent sport. So that is a protection under Title IX. However, based upon the requirements of football, the qualifications of football, in terms of if an athlete needs to have a certain amount of strength or a certain skill set, women might be more greatly burdened, particularly if there's an advantage to being taller, to being bigger, to being stronger. Women might be more greatly burdened. And it is not because they're being unintentionally excluded or discriminated against. It's just because that there's a particular characteristic that makes football players more successful, that makes football players perform at a greater level. Another example would be, so thinking of men and women, firefighting is often an example I like to use, in that in order to be an effective firefighter, you do need to be able to carry a certain amount of weight because you might be carrying people out of buildings. And so when considering the physiology of women and men, often women can be more greatly burdened by this necessary requirement. And so that would be an example of disparate impact, where it's not that you're being treated differently intentionally, but you have a greater burden in that case. And so you may be less represented, for example. But once again, with the 14th Amendment, so we're fitting a lot into this slide. I just want to draw your attention to how how important of a discrimination legislation this is, how important it is, such a great protection for marginalized and disadvantaged groups who have historically been oppressed and discriminated against in our country. And so the 14th Amendment is one I just really want to resonate with you, that similarly situated people should be treated similarly, but in your future role as a sport manager, how can we make sure that all people are treated similarly? But also, which I'll have a future slide on, how can we work to um, to to increase the access to opportunities, to equal pay, to all of the amenities, accommodations for marginalized people groups who have historically been discriminated against. Because, yeah, it's such an issue that I want you to take a moment to really think about this particular amendment. When it comes to the 14th Amendment, there are different standards of review that the courts will use. Now, these standards of review actually apply to other amendments as well, such as the First Amendment. And in this process of, those questions I had, I highlighted that the courts will consider, is it a state actor? Is the conduct a search? Is the search reasonable? Things of that nature. All of that information really informs the court's standard of review, which is the burden of proof on the defendant. So on this slide, you will see the 3 different standards of review. And as you can see, so mere rationality is the lowest standard of review. In a lawsuit that applies mere rationality, the state actor, so this is the defendant, must prove that the classification, so treating this one people group different from another people group, is rationally related to a legitimate governmental interest. Okay, so we're always going to look at what governmental interest is served by treating similarly situated people differently. So in mere rationality, you just have to prove that that discrimination, we'll say, is rationally related to a legitimate governmental interest. In intermediate scrutiny, you have to prove that that discrimination is substantially related to an important government objective. And then in strict scrutiny, you have to prove that that discrimination is necessary to achieve a compelling governmental interest. I hope you can tell not only in my inflection, but also in the graphic below, that of the level of burden that continues to increase as the standard of review advances. So mere rationality is the lowest burden of proof for the state actor. It's the easiest to prove in court. Intermediate scrutiny is a bit harder. Strict scrutiny, oh my goodness, it is almost impossible. It is a very, very stringent test. Very few state actors have ever survived this test and been able to prove that their actions are constitutional. And so this review really, it determines the burden of proof, which will then inform a court's decision. It's kind of going back to like civil versus criminal court. Do you need to prove a preponderance of evidence, or do you need to prove beyond a reasonable doubt? Those are very different burdens of proof, which will inform the final judgment. Now, when thinking of, well, what standard of review is the court going to apply? It really depends on the classification of person who was discriminated against or whose constitutional rights were violated. So under mere rationality, which is the easiest standard of review, often we will see residency classifications, so treating residents different from non-residents. For athletics, we'll see engagement in extracurricular activities, eligibility rules like transfer rules will fall under mere rationality, age rules for sports. So those rules have often been challenged under mere rationality. And then intermediate scrutiny, often Gender and illegitimacy are the classifications in which intermediate scrutiny would be applied. We'll focus on gender in this case. And so it is because of like the equal protection clause that women have gained the right to try out for contact sports teams. However, under intermediate scrutiny, in lawsuits, men have been less successful when filing an equal protection lawsuit to try and gain access to traditionally female sports because the government found that the state actor treating male athletes differently than female athletes is substantially related to the important governmental interests in redressing past gender discrimination in sport. I just wanted to show you an example of when treating populations differently. So women gained access to male sports, but why did men not gain access to female sports? Well, they actually did find a governmental interest served in treating those populations differently in sport. So if the lawsuit is discrimination based on gender, it would fall under intermediate scrutiny, and then going to strict scrutiny, which is the most stringent test. The courts will consider fundamental rights deprivation, as well as there are certain what are called suspect classifications. So under fundamental rights, you have your freedom of speech is a fundamental right. If your freedom of speech is violated, the courts will apply strict scrutiny. All right, that is how much protection you get under the First Amendment, which is amazing. You have the right to peaceably assemble, to vote, to travel, to marry. All of these fundamental rights, you get the greatest level of protection. Now, as a clarification, sport is a privilege, not a right. So it would not fall under strict scrutiny. And then what the courts can call suspect classifications are race, national origin, and alienage. So if you are international, for example, and once again, strictest test, like there is rarely, if any, governmental interest served by treating someone differently because of their race, right? In my mind, there's no reason ever to treat someone differently based on their race, national origin, and alienage. So greatest level of protection. I wanted to show this slide for you. It is a flow chart that one of my colleagues created and I found to be really helpful in terms of, the courts go through a lot of questions to figure out how should we judge this case. And so I really like the flow chart. You always start at the top with the number one question: is the defendant a state actor or not? If not, hey, you know what? You need to stop there. If they're not a state actor or their conduct isn't state action, then they are not subject to the Constitution. But if they are, then you're going to look at, all right, what right was violated? If it was a fundamental right, then the courts will apply strict scrutiny. If it was not one of these fundamental rights, then we're going to look at, equal protection clause, is it purposeful discrimination or is it unintentional discrimination? If it's personal, we're going to look at who is discriminated against. If it's based on race, it's once again strict scrutiny. If it's not based on race, is it based on gender? Then it's intermediate scrutiny. If it's not based on gender, then is it based on basically any other classification that is not covered under intermediate scrutiny and strict scrutiny, just so you know, would then fall under mere rationality. It's kind of a catch-all here. Age, disability, then the courts will apply mere rationality. Going back up here, equal protection clause. If it's not purposeful discrimination, stop here, because the equal protection clause only prohibits intentional discrimination. So I hope this flowchart is helpful for you. I found it really helpful in trying to figure out, all right, well, what a case, where would it fall? How would the courts review it? And then lastly, I just wanted to briefly touch on legal remedies. So this would be if the defendant, so the state actor, was found guilty of violating a constitutional right. And in injunctive relief, So injunctive relief is designed to prevent future wrongs, not punish past actions. In this case, the wrong has not occurred yet, or the wrong, it's actually possible to prevent the wrong. So we're not trying to remedy an injury, right? And provide some type of monetary compensation for damage that was done and cannot be undone. This is trying to prevent future injury. So anytime an injury is considered irreparable, so if you have risk of physical harm or death, I mean, if you were on, death row, worst case scenario, loss of a special opportunity, deprivation of your property, all of these wrongs could potentially be prevented through injunctive relief. So an injunction is a prohibition against an action. So an injunction prohibits an act, while specific performance, that fourth bullet point on this slide, is a little different. It actually commands an act. So these first three, prohibit an act, this fourth one commands an act. With a temporary restraining order, this is issued to a plaintiff in an emergency situation. So typically, if a lawsuit is filed, and we'll talk about a plaintiff, and let's see, okay, professional athlete receives a suspension from the league and is asked to sit out for 3 games. And they file a lawsuit stating a constitutional violation. And the harm hasn't happened yet. Those games haven't happened yet. The sanction is about to be enforced. They know they're suspended. They know an upcoming game they are not allowed to play in, but that harm hasn't happened yet. But guess what? Lawsuits take forever. And so that athlete could file a temporary restraining order to make sure that the sanction is not enforced. So that's why the injunction is prohibiting an act. A temporary restraining order, the plaintiff would file, it only lasts for 10 days. So it's literally, it's very, very temporary. It's, you know what, I will experience an injury within the next 10 days. I need immediate action by the courts. I will face irreparable harm, and monetary compensation is an inadequate remedy. I need you to stop an action. So the plaintiff would file a temporary restraining order before the trial. And a court would evaluate it and either overrule it or uphold that temporary restraining order. And the defense has no involvement. They actually aren't given notice of a temporary restraining order. However, when it comes to a preliminary injunction is the plaintiff is asking for an injunction for a longer period of time. While the temporary restraining order only lasts 10 days, a preliminary injunction, that request is for an injunction to last throughout the duration of a trial until the final judgment is made. And as we all know, lawsuits can take a really long time. And so it is to make sure that the sanction, for example, cannot be enforced throughout the duration of the trial until a judgment is made. But in this case, the defendant actually is given notice and they can argue against it. So it's almost like a mini trial before the trial, just to determine whether the court should grant the preliminary injunction or not, because a defendant can make a case against it. And then there's the permanent injunction, and this would be the judgment after a full hearing of the trial. And a permanent injunction would be the remedy, would permanently prohibit an action. So in this case, if it was a 3-game suspension, the league would not be allowed to enforce that suspension at all at any time. And then specific performance, while it falls under injunctive relief, I find it operates quite differently. So that's an interesting little fact, because it mandates an action. It requires you to do something. And in this case, we often see specific performance in contract law. So we'll talk about that more when we get to contract law. But it basically often, if a party does not fulfill their contract terms that they agreed to, the court could enforce the contract. and require that party to fulfill their end of the contract. However, the only time we don't see specific performance granted is in regards to a professional service contract, like a job, for example, because the US Constitution prohibits slavery. And so you can't make someone do something in that case. But I wanted to just come back to this idea of equal treatment and encourage you to just take a moment at the end of this lesson to think, reflect, act, and change. Because unfortunately, sport has a history of inequality, oppression, racial injustice, discrimination against marginalized people groups. So how can we move from inequality, not to just equality, but to justice, equity, inclusion? What changes can we make to these systems of inequality in order to offer equal and just access to all people?